Hello, this is William Nguta. Allow me to introduce you Professor Paleker, who will be presenting on wills and estate planning. Thank you.
Good afternoon, ladies and gentlemen. I need to apologize to you. I'm not going to scream too much. I've got a phlegmy chest, and it's that time of the year. Ladies and gentlemen, this afternoon I'm going to speak to you very briefly about wills and estates. And chances are you're going to have many questions that I'm not necessarily going to be able to answer because I don't have the expertise to cover every single question, and most specifically about taxation. So I'm going to put that out to you in advance to say that there might be questions that I cannot answer. I'll try my very best, and I'll take your email address and I'll email you later on. What usually happens after all of these retirement seminars is that I'll get back to UCT, and the day after I get all these emails from people asking me if I can draft their wills for them. And so I'm going to tell you this in advance already. I'm never going to find the time to draft all your wills. But I'm going to tell you about the possibilities that exist out there for you to have wills drafted at a very cost-effective manner. So, two things. I'm not going to be able to draft your wills, and I'm not going to be able to answer all the questions, but I'll try my very best. So they left me for last, because my job is to tell you about death. And I must say that everybody here looks very, very young, and you don't look like retirees, but I'm told that there's a second session, and that's for younger people, and that's like the end of August. But I'm even surprised who's coming here today, because none of you really look like you need to retire from UCT. But in any event. So let's start with the wills and estate planning. I'm also not very good with PowerPoint, because I don't teach with PowerPoint in class. What I usually use is a chalkboard, and I always find that is the most effective way of teaching people, as opposed to using these PowerPoint presentations. Absolutely hate them. Very bad at them. I never get them right at conferences, so I'm telling you about this advanced as well. Okay, so the first step to retirement, to estate planning, is having a will. It is absolutely amazing how often you would meet people who are quite aged, sometimes they're old, and you ask them, do you have a will, and they don't have a will. And it's interesting to note, because if you go to the Wills Act and you look at Section 4 of the Wills Act, the Wills Act says that every person 16 and above who has the requisite mental capacity may make a will, may execute a will. So this is very interesting, because our age majority in South Africa is 18, in the past it was 21. So even under our current Wills Act, children may make wills. And that shows you how important it is to have a will, because as soon as you are able to possess property and own property, you should actually be thinking about what is going to happen to that property in the eventuality of death. So my advice to you is, if you don't have a will, the first step to estate planning would be to have a will drafted. Now I'm going to tell you about how you should get this will drafted in a moment. But let me tell you what the second step to estate planning is. And that is to prepare what I call a death file. In the past, I practiced as an attorney. It was always amazing to me when people died. So they would have a will, which people would bring out from somewhere, be all crumpled, and they would present to the attorney. And then you, as an attorney, you would find it incredibly difficult trying to determine what property people actually owned. Because interestingly enough, and we found this, and you wouldn't know this, but in divorce cases, it's absolutely amazing how much property spouses conceal from each other. and in death, you would assume that you know about all the property that your spouse owns. But you'll be very surprised to discover that they've got a number of fixed deposits that you knew nothing about. And that they own shares in companies and in other institutions that you knew nothing about. And that they had IOUs in terms of which other people owed their money, which you knew nothing about. And so oftentimes what happens is that when somebody dies and you're an attorney, you really spend a significant infinite amount of time, wasted time. You see, the longer the attorney works on a matter, the more it costs the estate. But this is also part of estate planning, and that is the idea of having your affairs in order. Having a file which you deposit either with your attorney, or if you trust your spouse, you can leave it with the spouse, or you can leave it with your accountant, but which contains all the particulars of your assets, your bank accounts, your movable property, your movable property, property that you've got in a safe deposit box, whether it's jewelry, share certificates, whatever it is. And we found in practice that oftentimes you would spend about 6 months just trying to determine what somebody owns. Because the interesting thing about human nature is that when somebody dies, nobody comes to you and says, do you know that I owe your father 5,000 rand? Nobody does that. So you actually need to be proactive and you need to prepare this file in advance so that in the eventuality of death, all of this information is available to somebody and it's all in one place. So personally, at home, I've got an arch legal file, which I call my death file. It's okay to have it, it's not my car, it's okay to have it, to stare death in the face. So in it I would have my will, and I've got all the information relating to my life insurance policies, and to my pension funds, and the shares, and to the small fixed deposit that I have with the academic members of staff. I don't earn so much. So I have all of this information in one file, and that is my death file. So these are the two golden things that are trying to do. The one is you must have a will, and the second thing that you should have is a death file. Have everything in one place. It really saves a lot of time and expense to the deceased estate. Now, when you think of a will, this is the legal definition of a will. And in this legal definition, there's so many things that I can tell you about wills. So, a will is described as something which is written, unilateral, voluntary, deliberate, revocable, in a legally prescribed way which effectively disposes of a competent testator's property on death. Many people think that they can write a will on a piece of paper and then leave it in an envelope and that is fine. Ladies and gentlemen, your will must be properly formalized. In other words, it must meet all the formalities for wills, which is contained in the Wills Act. There's a particular section in the Wills Act, Section 2 of the Wills Act. It sets up formalities for wills. And our courts are so pedantic, and the masters of the High Court are so pedantic about formalities, that if you fall short of the Wills Act by one iota, the will will be regarded as being invalid. So there are actually cases in our law where somebody, the Wills Act says, that the testator must sign at the end of the will. The courts have said at the end of the will means at the end of the written dispositions contained in the will. And there was a scenario where somebody signed 9 centimeters below the last paragraph. And you know what the court said? That's not at the end thereof, and declared the will to be invalid. So ladies and gentlemen, you must never take the idea of formalities for granted. If you are unskilled in formalities, then you must obtain the assistance of a professional. Who would this professional be? There would be attorneys or accountants or paralegals, but people that actually know about the formalities for wills. Do not assume always that people with professional standing know about wills. The best, I'm not here to punish the attorney's profession, but ideally each and every one of you, it's part of like, you should have a good doctor that looks after your family. You should also have a good attorney or a family friend who's an attorney who knows about your affairs, and have them draft your will for you and make sure that it complies with the formalities for wills. What you also need to know is that an oral will is invalid. So even if I said, I met a friend and I sat down with a friend and I said, on my death, I want my estate to divide as follows, that's also invalid. Because according to our law, it has to be in writing. So it has to be in writing and it must be properly formalized. It's a unilateral act. In other words, when we have contracts, usually contracts are between parties. If I enter into a contract with you, it's between the two of us. But the interesting thing about the will is unilateral. It's my own juristic act that I enter into. So you don't need to consult with anybody else in your family. You can go to the attorney and you can draft your will according to your wishes. That is your right. But of course, there are times when you can draft a will with your spouse. And classically, where this happens is when parties are married in community of property. So, I'm sure many of you will know about the matrimonial property regimes. Probably all of you know about the matrimonial property regimes. We've got basically 3 matrimonial property regimes in South Africa. The one is in community of property, where 2 spouses pool the assets and they have a joint estate. And then you've got out of community of property without accrual, and out of community of property with accrual. And accrual means that you've got separate estates. So parties are married out of community of property, each spouse has their own separate estate. But on dissolution of the marriage, whether by death or divorce, the spouse whose estate has shown the greatest growth during the existence of the marriage, that spouse's estate will have to pay accrual, which is not evil, it's not an evil thing. They will have to pay accrual to the spouse whose estate has shown the lesser growth. And this is called an equitable redistribution. It's very fair. And I always tell my own students, as professional people, you should marry out of community of property, because what if you meet the spouse that shops till they drop, then you have a joint estate, you're all going to be liable together. But in the past, community of property estates was the norm. So if you are involved in a community of property estate, don't do alarm by what I'm telling you, but you basically have this joint estate. And when there's dissolution of the marriage, whether by death or divorce, this joint estate now splits. It divides. And what often happens is that the principal asset in a joint estate would be the matrimonial home, not so. And because there's this splitting of the estate, each party is entitled to 50%. What classically happens is that the matrimonial property, the matrimonial home, needs to be sold in order to achieve the neat split, so that the heirs of the deceased can receive their 50% of the joint estate. So what parties do is that they enter into a joint will. And in this joint will, they effect a massing. And they say that on the death of the first dying spouse, the entire estate will devolve to the survivor. But when the survivor dies, then that estate must devolve to the children. Now in that scenario, it's no longer a unilateral act. You've got 2 parties that come together and they make a joint will. But what you need to also know, see, there's so many errors, attorneys and lawyers know that there are errors. What you need to know is that when the first dying spouse dies, the survivor has an election. So even though they entered into this joint will, the survivor has an election. He or she can either accept or repudiate the joint will. And if they repudiate the joint will, then again, what will happen is that there will be the split. But in the overwhelming majority of the cases, because the purpose of the joint will is to protect the integrity of the joint estate, the survivor will not repudiate, and the survivor will accept the provisions of the joint will. But then they cannot make another will in the future, because the moment you accept the joint will on the death of the first dying spouse, you're bound to it. And if that will says that on the death of the survivor, the property must pass on to the children, and so be it. That's what's going to happen. So, although we talk about the unilateral act, there's an exception. Because you remember in law, there are always exceptions. And it's a voluntary act. So nobody can force you to draft wills in a particular way. You've got something which we call in our law freedom of testation. You can, if you wanted to, you could leave your entire estate to your monkey in trust. Nobody can prevent you from doing so. Because you've got freedom of testation. It's a voluntary act of testation. But there are exceptions to this general rule. For example, where your freedom of expression will be your freedom of testation will be limited would be if you have, for example, minor children. You can't now leave your entire estate to the new person that you met at the gym, for example. And those minor children are in need of maintenance because they would have claims against your estate. So this is all part of estate planning, because oftentimes people think I can do whatever I want. But the law has these breakers, and they try to prevent you from doing things which might be regarded as being morally reprehensible. For example, disposing of the entire estate and then leaving your children indigent. That's never going to work. What you also need to keep in mind is that your surviving spouse has a maintenance claim against your estate. There's a special act of parliament that deals with this, the Maintenance Surviving Spouses Act. So you might think my spouse is a nightmare on legs. When I die, I'm going to disinherit my spouse. If that happens, and your spouse is in need of maintenance, the spouse can go to the Master of the High Court and activate the Maintenance of Surviving Spouses Act. In which case, the estate would have to pay maintenance to the surviving spouse for their life expectancy. And that is a claim which is recognized by an Act of Parliament. So you see this general proposition that people have freedom of testation and they can do whatever they want. It's true, it exists to a particular point, but you cannot leave those that are nearest and dearest to you indigent on death. So this is all part of estate planning, and sometimes people don't know these things. So I tell you that because it's quite important. It's quite important to know about it. It's a revocable expression. Because interestingly enough, you can draft as many wills during your lifetime as you want. And in fact, my suggestion to you would be this afternoon, don't just draft one will. You need to draft many wills over your lifetime. I'm going to tell you why in a moment. Because that's also estate planning. So there's this assumption that if I go to the bank, and the bank drafts my will for me free of charge, there's this assumption that exists out there. If I go to the bank, and the bank drafts my will for free of charge, and I've nominated a bank official to be the executor of my estate, there's this assumption that I can never change my will ever again. Nonsense. You can draft as many wills during your lifetime as you wish. If you decide, and sometimes you do get very cantankerous testators, and if you turn and you know all about them, but you don't complain, because the more wills they draft, the more fees you earn. Sometimes I would say, this month, they've fallen out of the daughter-in-law, so I disneeded the daughter-in-law, and the next month they've killed the daughter-in-law, and disneeded somebody else. You can draft as many wills during your lifetime as you want. But there are exceptions to the rule. The one rule would be the mass estate, where there's a joint will. The first time dies, the survivor says, I abide by the provisions of the joint will. If you abide by the provisions of the joint will, then the consequence is that you cannot draft more wills again in the future. You must follow the provisions of the joint will. So that's the one exception. The other exception to the rule that you can draft as many wills as you want is testamentary provisions contained in an antenuptial contract. Oftentimes, if you read antenuptial contracts, I don't know what is in yours, people will say that on dissolution of the marriage, which means death or divorce, doesn't matter, the immovable property situated at Woodstock, or the matrimonial property, or the matrimonial home will go to the wife, or to the husband, or to children, or whatever the case is. It's contained in the antenuptial contract. Provisions in an antenuptial contract, you cannot override. Those provisions stand. So the general proposition again is, you can draft as many wills during your lifetime as you wish. But the two exceptions, the antenuptial contract and the joint will where there's been amassing and the survivor has accepted the provisions of the joint will. So keep that in mind, okay? And then, I told you about the fact that you need to have proper formalities for wills. So oftentimes people go and they buy the 1495 CNA will because in some way, for some odd reason, when it comes to law, we assume we can always do it ourselves. So we never pull out our teeth ourselves. We never switch our hands ourselves. We go to doctors for these things. But when it comes to law, oftentimes we find that people will go to CNA and they're going to buy the 1495 will because, as the South Africans, it's the same. They want to go to an attorney. So what do? They do the 1495 CNA will. Ladies and gentlemen, I can tell you that in my experience, not only teaching the subject matter of what I teach, but also in practice, 80% of those walls land up being defective. The master does not accept it. Why? Because the formalities have not been complied with. Oftentimes, the 1495 CNA wall, you have to fill in all the blanks. The moment there's a space that's open, the master sees the potential for fraud, and the master says the master is not going to accept that wall. And the result is that people die intestate. So my advice to you is, when you're drafting the law, if you don't know what you are doing, go and make an appointment with an attorney. You don't have to go to the most expensive attorneys in town. They occupy very fancy office spaces on the foreshore. You can go to a local attorney because drafting the walls is not that difficult. And you can also bargain with an attorney with regard to price. So oftentimes people think, if I go to an attorney, I'm going to pay 5,000 rand for a wall. Not true. You can go to attorneys, you can phone them and say, what do you charge for a wall? And then you can make an appointment based on the fee tariff. And different attorneys have different fee tariffs as long as it's within the law society, right? Because these things are regulated as well. So you should go to an attorney, or to an accountant, or to a financial advisor, and make sure that you've got a proper wall. And then you need to make sure that that wall is in a safe place, that it can be found later on. And if you're going to an attorney, it will probably be put in a safe, in an iron room that will be protected in the event of a fire or anything else, and it can be retrieved. So formalities I cannot understress, because people oftentimes, this last leg, they get it wrong. They draft a beautiful wall, and then it falls foul of formalities. Now, what's the problem with dying intestate? If you don't have a wall, right? If you don't have a wall, you've never drafted a wall at all, or you have a wall, but the wall does not comply with formalities for walls, the consequence is that you die intestate. And this is regulated by the Intestate Succession Act. And now, when you die intestate, your entire estate evolves by operation of law. And it's very interesting the way it all works. I'm not going to teach you intestate succession, because that could be like 2 lectures on its own. But I'll tell you some of the consequences of it. Let's say you've got children, you've got a spouse, you've got parents, and you have nephews and nieces. And you would like to benefit all of those people. Interestingly, if you die intestate today, only your spouse and your children will inherit under intestate succession law. Your parents and your nephews and nieces will not inherit. Because the way in which the Intestate Succession Act works, it's by operation of law. Nobody can change it. It's the way in which the legislature has crafted the Intestate Succession Act. So this is why I say to you, be very careful about dying intestate. Let's say you've got a spouse, you've got no children, but you've got parents. Under intestate succession law, your spouse inherits your entire estate to the exclusion of your parents, because of the way in which the Intestate Succession Act works. So, do not be blasé about it. Don't assume that the intestate succession laws will necessarily give effect to what would be your heartfelt desires, because it might not be the case. Okay. And I told you about freedom of testation and this idea that you can dispose of your property as you wish, save in those 2 circumstances that I told you about. Now, I'm going to tell you very briefly about testamentary vehicles, because there's so much to tell you about succession law. But testamentary vehicles, oftentimes people don't know about. So, the one testamentary vehicle is a bequest. I leave specific property or specific amounts of property to a particular individual. Will they get the property? Yes, they will, unless there are certain things that cannot be met. One of the great problems when it comes to the devolution of estates is the issue relating to liquidity. Oftentimes, people don't make provision for liquidity in their estate. And they die leaving insufficient, so they've left all these bequests, but there's not enough liquidity for what? For paying estate duty, for paying the receiver of revenue income tax for that particular year, for paying funeral and deathbed expenses, for paying the master's fees, the executor's fees, the attorney's fees, and all of those fees. So what happens then? These bequests are abated. In other words, I want to leave my daughter R1 million, but now she can't get the R1 million, she's only going to get, let's say, 800,000 rand. Why? Because somebody has to pay for all of these other expenses, the receiver of revenue and estate duty, capital gains tax, and all of those things. So those bequests are abated, they are reduced in order to make provision for these expenses. So you must, when you're thinking about estate planning, you must think about the issue of liquidity. Is there sufficient money in my estate to cater for all of these expenses? So what do? What people generally do is they leave bequests, and then they also make provision for a residue. They say they leave bequests. They say, I leave the house to my daughter and the car to my son, and I leave the fixed deposit to my grandchild, and all sorts of other things. But then they would also have, for example, a life insurance policy, which will be payable to the estate. And what will this life insurance policy generally do? It will say, well, it will pay for all these other expenses, but then it will have a residue clause. And it will say, the residue of the estate, in other words, whatever is left over after all of these bequests have been paid, the residue of the estate will now devolve as follows. And then you can leave it to the same beneficiaries, but it's what's left over. But the issue of liquidity is very important. And oftentimes, this is the part of it that's underestimated. Because remember, the receiver of revenue doesn't care that you die. The receiver of revenue wants their money to do all sorts of nice things with it. Okay. Usufructs and fideicommissums. So, a usufruct and a fideicommission is something that you probably find very, very funny because you've never heard of these things before. Well, you've got, by all means, you can find it funny because usufructs and fideicommissums really come to us from Roman law and the Roman Dutch law. And today, we don't, and I'm going to tell you about whether or not usufructs and fideicommissums are much in vogue these days. They're not, but you still can use them. So what is a usufruct? You remember I told you about this mass estate, where parties are married in community of property. And they said on the death of the survivor, on the death of the first dying, the survivor is going to get the estate. And when the survivor dies, the property must pass on to the children. That's basically a usufruct. It's a right of use and enjoyment, an intermediate benefit of right of use and enjoyment, subject to the obligation that you pass on the property later on. So your attorney will never tell you you're creating this usufruct, but that's what you really are. And so wills and the way in which wills are drafted makes provision for this idea of a testamentary vehicle of a usufruct. Then we've got something called a fideicommission in our law, which is a successive interest. I say that on my death, the property must pass to my son. But when my son dies, it must pass to my grandchild. That is a successive interest. It's called a fideicommission. And this is also a testamentary vehicle in our law. But the Fiduciary Institute of South Africa tells me that when all their members advise people in estate planning, they say to them, don't worry about the usufruct. Don't worry about the fideicommission. Go for the trust. Because the trust is the best mechanism by which you can protect your property. So let me tell you about trusts. Because trusts, I think, are incredibly useful. When are they incredibly useful? You've got an aged parent who you anticipate that by the time of your death, because we don't know when we're going to die, we could die this afternoon or tomorrow, but you anticipate that this aged parent will not be able to look after themselves. So what you do, you leave you leave money to the aged parent. But you know that this aged parent might not be able to look after themselves. best thing to do is to leave the property in trust, in a testamentary trust. In your will, you create a trust. And you say that on my death, I leave R1 million to my mother, but it must be placed in trust. And then you stipulate who the trustees are, invested or whoever else, and they must administer this trust, this testamented trust, on your behalf, and they will take a fee, an administration fee each year for doing their functions. But they will administer this trust and make sure that your intended objects and purposes are satisfied. So that's a possibility. When else would you do it? It's when you've got minor children, which many of us, or minor grandchildren. I want to leave my minor grandchild a sum of money. Now, if the child is 7, 8, 14, or 16 years old, or even 18, I would say, because even 18-year-olds are very immature these days. So, you want to leave this person some money. But you know, firstly, you can't just leave a child money, because under law, the child has no capacity to receive the money. The money would have to be placed into the guardian's fund. And you also have to know that if you leave money to an 18-year-old, the first thing they're going to do is they're going to buy a Ferrari and not necessarily spend the money on education. Again, ladies and gentlemen, what do? You put it in a trust. And you create trust. You give powers to your trustees. And you can actually stipulate what the money must be used for. Education, weddings, gap years overseas, whatever it is your heart's desire, you can stipulate what the proceeds of the trust must be used for. So the vehicle of the trust in modern South African law is incredibly useful. In fact, it is more useful than the usufruct, and it's more useful than the fideicommission. So I would highly encourage you, if you go and explore estate planning with financial advisors, or with your attorneys, or accountants, that you think about the trust, that you ask about the trust. Because a trust is a very, very useful vehicle in our law in protecting your assets and making sure that your intended objects and purposes are satisfied. And oftentimes we don't think about these things. So if you think about the advantages of trust, it's an instrument that sets up one's aims and objectives. It's perpetual, it can go on forever. For example, like the Cecil John Road Trust. It can go on for as long as there's money. Bill Gates' trust is going to go on for eons because there's just billions in it. And one would like to be a trustee of one of those trusts. And then, as I told you, you can protect the interests of young children. So that's very neat about the trust. Possible charitable bequests, like Cecil John Rhodes Trust. You can leave property in a trust for a charitable purpose. And each year the trustees must pay a particular amount of money for this charitable purpose, cancer research or whatever the case is, HIV, AIDS or anything else. But you can also stipulate the capital of this trust be reinvested from time to time. And then only the income that is generated be paid over to the charitable institution so that it carries on forever. So that forever the angels are singing your praises in heaven. And you can know that everything is fine. Okay? So, and then you can protect the interests of vulnerable and disadvantaged individuals. For example, aged parents who might not be able to look after themselves, so you leave it in trust. You've got children suffering of some kind of disability, mental or physical, and you want to make sure that this child is well cared for. Leave the property in a trust. Don't give it to people to give to the child, because the nature of people are such that they take the money for themselves. So leave it in a trust. And you might think that I'm being very harsh, but if you practice as an attorney, you really get to see the good sides of people, but also the very bad sides of people. So I'm telling you about these things because these things really do happen. And obviously, you can use the trust to look after your parents, okay? So we also discussed freedom of testation. I told you about this idea that we've got freedom of testation. I told you about the Maintenance of Surviving Spouses Act and the common law duty to maintain your children, so you cannot leave your children destitute. Now, the interesting thing about children is that there is no age at which maintenance ceases. There's this aging case in our law of a 56-year-old woman who applied for maintenance from her father's estate. And the court granted it because she was in need of maintenance. She was physically, she was mentally impaired. The court granted. So, for example, I cannot, if my parents die, I cannot just suddenly decide, okay, I'm going to give up a job at UCT and I'm going to claim maintenance. Exactly, creating my own need. But the courts look at these things very pragmatically, and if there are children, it doesn't matter their age and their need of maintenance, they can bring a claim to deceased estate. Okay, so we know these things. And then the Constitution, which I think every one of us need to know about. And I don't think any one of us here are nasty and mean people, but sometimes you do find people that are quite nasty and mean, and they put conditions in walls that says all sorts of nasty things. For example, you cannot marry this one, you cannot marry that one, or they will say there's nothing wrong with leaving a bequest for a particular religious purpose or to a particular religious denomination, no problem at all. But there are cases in which our courts have said, for example, you cannot discriminate against people arbitrarily on the basis of race and gender. And it's even a case which involves the University of Cape Town. Cyphers versus the University of Cape Town, a decision of the 10th Provincial Division of the High Court, in which the court struck down a particular provision because this person said that the bequest may only be used for the education of white genteel males, and the court said that that was unconstitutional. So ladies and gentlemen, we must be careful about these things, but yet again, if you get proper estate advice, estate planning advice, you won't fall foul of these rules, because any attorney who knows anything about the law of succession will be able to give the proper advice. Okay. So let's look at, I told you about the formalities of wills. I also told you about the consequences of invalidity. So I told you I'm very bad with PowerPoints. I can never keep to them. So I told you about the consequences of invalidity, and I told you about the dreaded C&A law. You're never going to have the dreaded C&A. You can use it, but you must know what you are doing. Contents of laws, restrictions and conditions in laws. I'm not going to bore you too much with this, but I'll just tell you something very briefly about these things. You can impose conditions. I can say, for example, I leave R1 million to my son on condition that he acquires a BCom degree as an incentive. That's not a problem at all. It's got a laudable purpose. Question mark in our law. Can I leave R1 million to my son on condition that he only marries a Muslim person, for example? This is subject to a question mark, undecided. Some of the academic writers say no, some say yes. So one is very careful about these things. Time clauses. I can stipulate in my will when something must be paid. So if I think my children are very immature and they're 18 at the moment, I can say, I leave R1 million to my son, but must only be paid on his 25th birthday. That's not a problem at all. So there's no idea in our law that when somebody dies, immediately the bequest or immediately the inheritance has to pass over. As a matter of estate planning, you can decide when the property needs to be passed. So oftentimes people say, I leave my estate in trust until my child turns 25, and then the proceeds will be paid. Because you're hoping at that stage they'll be less immature and they're going to spend the money more productively, as opposed to using all the money to buy a Ferrari. Okay? But I say it is preferable to leave a bequest without any restrictions, because then there's little scope for people to challenge the law. What oftentimes happens is that when there's conditions, people challenge wills for all sorts of reasons, and that's why I'm saying to you, try to steer clear of the conditions unless you know what you're doing and you've got some kind of laudable purpose. Now, let's talk about executors, because people always ask me about the executors. Who should you nominate as the executor of your estate? Can you nominate a lay person? Ladies and gentlemen, you can nominate your spouse, your children, your grandchildren, you can nominate anybody that you want. Provided, of course, that they are not two marbles short of a dozen. As long as they say, you can appoint them. Can you appoint your minor child to be the executor of your estate? Or a minor grandchild? The answer is yes. You can appoint them in your will. But the difficulty will be if you die at the time when they're still minors. Let's say you die and you left your grandchild as the executor and your grandchild is only 16 years old. The Master High Court will never give letters of executorship to a minor. They're going to then appoint an alternative executor until such time as that minor reaches the age of majority. So yes, of course, you can nominate your children, even though they're minors, but keep in mind, you need to be fairly certain that they will be majors at the time of your death. And then you'll overcome that particular problem. What I would suggest to you is you must always nominate an alternative. So say, I nominate my son John, and in the event that John cannot be the executor, then I nominate my daughter Jane. Absolutely fine to do it that way. Nominate alternatives. Why do you nominate alternatives? Because John might have predeceased you and you never changed your role, or John might lose his or his senses, or something might happen and John says, I don't want to be the executor. Then you've got an alternative, and you've nominated that person in your will. If you don't have this alternative, the master will appoint an executor, usually a member of your family, but it leads to additional delay because now they have to have family conferences and all sorts of other things in order to find this alternative executor. So you can nominate lay people, but also my suggestion would be that you think about appointing an alternative executor, a substitute executor, in the case of the person that you really want cannot be the executor. You should give your executor the power of assumption. So what is this? Also estate planning. Winding up an estate is no easy business. It's regulated by the Administration of Estates Act. It can take 6 to 8 months to wind up a small estate, sometimes 2 years, because there's all sorts of things that you need to do. You need to advertise to creditors in the government gazette in a local newspaper. You have to open up estate banking accounts. You have to draft provisional and final liquidation accounts. All of these things need to be done according to the Administration of the Estates Act. But we as lay people might not know how to do it. So what we do is we give our executors up. If you nominate your spouse as the executor, you say, I give my executor the power of assumption. What this does is that it allows your executor to appoint a co-executor to assist him or her in the administration of the estate. So if I nominated my spouse, I then say my spouse can nominate a co-executor. And this co-executor will classically be an attorney, because attorneys do the administration of estates. But you see, if you don't do it, if you don't give them the power of assumption, the law is not going to say that they can appoint co-executors. What they're going to do is they're going to be able to appoint an agent. And then there's an entire question mark about who is going to pay this agent's fee. Because the heirs don't want to pay it, the executor doesn't want to pay it, but if you put the power of assumption and you say that the co-executor can be paid a professional fee, then that takes care of the entire problem. So this is also part of estate planning, which oftentimes is lost on people because they buy the CNA rule and the CNA rule says nothing about the power of assumption. And in the actual practicalities of winding up, it's the reason why an estate 5 years down the line is still not yet wound up, because the executor doesn't know what he or she is supposed to be doing. And everybody becomes very, very upset. I cannot tell you the importance of drafting a will that you understand. If you go to an attorney, or a financial advisor, or to an accountant, and they draft a will, and you read it, and you say, my word, what the devil is this guy talking about? Then there's a problem. You must insist that your will is drafted in plain English, that you understand very clearly what it is that you're leaving and to whom, and what the terms and conditions of the bequest are if you're not in. If things are obscurely worded, it's going to probably mean it's vague. Maybe attorneys might know what they're talking about, maybe they might not. I cannot tell you how many cases come before our courts each year on the question of interpretation, where people bring cases to court because the world is capable of double meaning, 2 or 3 interpretations. Why? The principal protagonist, the testator, is gone. So you cannot say to the testator, what do you mean? That person's gone. The attorney that drafted the will might also be gone from the picture. And the witnesses that witness the will, one doesn't know what the devil they are. So nobody knows what this will means. And so they go to court, and it's only the High Court that can interpret wills, and they say to the judge, can you please tell us what this will means? And now the advocates fight it out, and 200,000 rand later, the court says, aha, this is the interpretation to this particular provision in the will. But they say to pay all this money in order to get that meaning stipulated. So the importance of drafting will, this is estate planning. The importance of drafting will that is clear and capable of meaning and that you understand is very, very important. Because anything can be simplified. I can present this talk to you in a very complex way today, but I'm trying to do it in the most simple manner. And so I say to you, draft your will also simply in a language that you can understand. Okay? And insist on it. If you don't understand it, don't sign it, because it means that there's a problem. I told you about this issue of liquidity, making sure that there's sufficient liquidity in your estate to pay for all the estate debts. That's critical when you're thinking about estate planning as well. And then this idea that you must revise your will every 5 years. Now, interestingly enough, and that's why I said to you, I have a will, but I need to go and have a look at it. Because I drafted my will many years ago. And I was thinking about it this morning. I actually have to really look at it. Why? Because oftentimes what happens is that your property changes. You had a house in Woodstock, and now you moved it up, and you bought a house in Rondebosch. And then you sold the house in Rondebosch, and you moved up, and you bought a house in Constantia. But your will is still talking about the house in Woodstock. Now you see, ladies and gentlemen, when you die, you will die partially intestate. If your will says nothing about your house in Constantia, because the Master High Court and no other person has the authority to amend the provisions of your will or to substitute your intent. Your intent must be clear on the provisions of the will. So it is vitally important that your will be up to date. And what often happens is that you have a will that says, I leave property to my spouse, or I leave property to my parents, but that spouse has maybe died, or you've divorced, or your parents have passed on, whatever the case is, those people no longer exist in the picture. You cannot substitute the will of the estate for anybody else. So every 5 years, as part of estate planning, as you will relook your pension funds, and relook at your medical aid scheme, what you must be doing is that you must relook at the provisions of the will. Look at it and say, is it still current? Is it stuff that I want to add? Is it stuff I want to take out? Or the people I want to take out, or the people I want to add in? So this is not the cantankerous testator. This is the prudent testator. The cantankerous one is the one that comes every 2 weeks and tries to change it. But I told you, we're not worried about those people in the attorney profession too much. Okay. So, the importance of estate planning. And maybe I should have put this first, but I've tried to contextualize why estate planning is so important for you. People always think of estate planning as something otherworldly because, you know what, it's 50 years down the line and I don't want to think about death, but it's part of financial planning. As you plan your finances, you need to plan that last part of your journey of earth. All of us need to do it. You can structure your estate according to your own wishes. Nobody can force you, but it's very good to have sound advice. So when you go to some of the larger law firms, I'll tell you what you will get. And again, I'm not punting the attorney's profession to you, but I'm trying to explain to you what services you'll get. You'll get somebody that's going to sit down with you in a consultation and take instructions. Depending on the size and the complexity of your estate, because I don't know what you own. Maybe you've got yachts. Maybe you've got houses and barns. I have no idea. But depending on the size and complexity of your estate, that person who takes the instructions will now say, okay, we need to get a tax consultant to structure your estate in a particular way so as to save your estate duty and capital gains tax. Because interesting enough, do you know this? If you left property to your surviving spouse, it's deductible for the purposes of estate duty. So sometimes, even when you think your spouse is a nightmare of pigs, it might be better for you to leave property to your surviving spouse as opposed to anybody else, so that you attract less estate duty liability. So they'll give you tax advice, and they'll give you overall financial and estate planning advice. And we can go to people like Intestate, and it depends again on how much money and property you have, the complexity of your estate, shares and all, the benches and all sorts of other things that you might have, which I'm not going to know about on this occasion, and chances are you're not going to want to tell us about it. But often people are penny wise and pound foolish. They go and they want to do it as cheaply as possible. And then they think to themselves, I've got it all done. And then when they die, you won't know what I'll say. But your estate demands are paying lots of estate duty, which could otherwise have been saved, and you could have left some more money to your grandchildren, but now they don't get it because the receiver revenue has taken a huge chunk off. And then there's this idea that you can also plan your estate in such a way so as to put property out of the reach of your creditors. And one of the ways that people do it is by taking it into Viro's trust, a trust during your lifetime. So if you are a very rich person and you want lots of money and property, you can already start now divesting yourself of property and putting it in trust and planning your estate for the next 50 years. These things are possible. But my advice to you again is be very careful about that. Because if you're not a very rich person and you need property from time to time for collateral and to get loans or whatever else, don't be too eager to divest of your property, because once it's gone, it cannot be recovered. You're basically divesting your property to a third-party entity such as a trust, so you must be very careful about it. So people always say to me, is it okay if I put all my property in a trust during my lifetime? It depends. Generally speaking, 9 out of 10 times is not a good idea, because the moment you divest of your property, you lose control over it. And all of us need to keep control over our property and our finances, especially as we're getting older. And it's never a good idea to simply divest of your property. So, steps you should take before going to your lawyer. Find out your attorney's fee for drafting. No shame at all. Okay? And bargain with it. Then you must plan. Oftentimes, if you go to an attorney, they're going to charge you R1,000 for a consultation. And so you don't actually want 3 consultations, you just want 1. So if you plan your consultation, think about what you're going to tell them in advance. So be a bit common sense about it. Think about what they're going to ask you. They're going to ask you for your children's ID numbers, and they're going to ask you for your ID number, and they're going to say what property you own, and what your cash numbers, and what your bank account numbers, and all of these things. Because maybe they want to put all of those things in a bowl. They have all of those things prepared, so that when you go to the attorney, or to the person who's going to charge you professional fees, you're just going to pay for 1 consultation, as opposed to paying for many consultations, because you don't have all the information at hand. And then think about the aims of your estate. What is it that you wish to accomplish? Do you have some laudable, charitable intent in mind? Are there children suffering with a disability or any form of other impediments that you want to care for? Grandchildren, parents, whatever. Think about it before you go and speak to this person, so that you can give them as much information as possible. You cut down on the time and also the costs. And then I told you about the death file, the very important death file that each and every one of us should possess. And you can obviously make arrangements with your lawyer to liaise with you by means of email, there's all of these things are possible, so there should be. And the reason I put this in is that people always think, it's a big long annual will drafted. It's not. It's very simple, and you must try as quickly as possible. If you don't have a will and your will is not updated, you must try to have it updated as quickly as possible, because these things are not very difficult. So, ladies and gentlemen, very briefly, that was wills and estate planning and the importance of it. And of course, my colleague Nominating is here from the request office, and he's going to come and speak to you after I've taken some questions from you. So don't ask me too many difficult questions. But he's going to come and speak to you about the benefits of, for example, leaving, and we are not here to take your money, to the University of Cape Town, for example, the request office. And he's going to chat to you about that. Charitable bequests and how you can actually save income tax as well as estate duties. And it's very laudable to do it also. So, does anyone have questions on stuff that I might not have covered? Because I'm sure there might be many things that I never covered. Yes.
I've got a question regarding the status of a partner as opposed to a spouse.
Very good question.
Yeah, and with regard to various aspects of
Okay. So the question is, what is the status of a partner as opposed to a spouse? Firstly, when you think about a spouse in the past, we only think about spouses married in terms of the Marriage Act, not through any law. In a number of judgments, the Constitutional Court has extended the definition of spouse for the purposes of the law of succession. So there was this case called Bear versus Magistrate Kailicha. It extended the definition of spouse to include a spouse married by means of African customary law. Right? So if you've got multiple spouses in African customary law, they're all your spouses. For the purposes of the law of succession. There was a case of Daniels versus Campbell, which dealt with monogamous Islamic marriage. They said it's a spouse for the purposes of the law of succession. There was a case subsequently, there was a case of Hassan versus Jacobs. We dealt with a polygamous Islamic marriage. Court said spouses for the purpose of the Intestate Succession Act. There was a case of Raghavati versus Governor, a case dealing with a Hindu marriage, the spouse for the purposes of the law of succession. So when you think about spouses, we're thinking about them very, very widely. But what is, and then obviously the case of Gotti versus Carver, which dealt with parties in a same-sex union who owe each other reciprocal duty of support. Constitutional Court held spouses for the purposes of the law of succession. But what the Constitutional Court has not held is people in a heterosexual cohabitive relationship. Those are not spouses for the purposes of the Intestate Succession Act, or when thinking about succession in general. If you want to leave property to your cohabitant, you must do so by means of direct will and specific leave. You cannot refer to them as your spouse because they're not your spouse. So you leave it to them specifically in your will, and you see if you die intestate, they will not inherit at all. Constitutional Court has held that cohabitation is not the same as marriage. I'm just telling you a snapshot of what the Constitutional Court has held. The Constitutional Court writes very long judgments, sometimes 50 and 60 pages. Even the students get upset when they have to read it. So I'm not going to take you through the whole the Constitutional Court's analysis of why they didn't want to hold the cohabitant as being a spouse. But that's what the court has held. Okay. The spouses is defined widely, but does not include the heterosexual cohabitant. That person still need to make a specific request in a valid will. Okay. It will not be regarded as being an intestate spouse. Yes.
Hi, I just wanted to check, you mentioned that when you have the joint will, and then the surviving spouse, they accept the provisions of the will at the time of death of the first dying spouse, because then everything is sort of as they want it to be. But now what happens if 10 years later circumstances have changed, the surviving spouses had another child, and they actually want to go and change their will if they're now going to die?
They will not be able to do it.
So then the surviving spouse has to repudiate the will.
So let me tell you how it would work.
Yeah.
All the property that is jointly owned by the parties at the date when the survivor accepts is frozen. It must then pass according to the provisions of that law. If the survivor acquires new property, because he or she is self-employed and has other, but they acquire their own new property after the death of the first time, that new property is not affected by the joint will. They can then, with that, as regards new property they acquire, they can then leave it to the children that are subsequently born, or whatever the case is. But the original will stands as regards the joint estate as it is on the death of the first dying spouse. Okay? Because you've accepted. Okay?
The alternative would then be to not have a joint will, to have two separate wills, but we stipulate.
You can have separate wills in which you leave each other property, and you can actually say, I could, for example, say that on my death, if I made an income in the property, I can say the matrimonial home must go to my spouse for the duration of my spouse's lifetime, and when my spouse dies, then it must pass to my children. That's what I should do. But all of these things is stuff that you'll discuss with your attorney. Okay. But very good question, and I can see that you actually understand the notion of a mass mistake, and that's very impressive. Okay. Yes.
Must all changes to the will, no matter how minor, must they all go through the master of the court again? And does it have to be done by a lawyer, or can you do it directly?
No. You don't register your will ever with the master. So I go to my attorney, I draft my will, I pay my attorney a fee, my attorney gives me my original will, or I leave the original will with the attorney, fine. The only time the master is involved is on death. Then you report the estate to the master under the law of probate. Something that you keep in England or Scotland. In fact, our law is very much based on the law of England and Scotland. So you go through the system of probate. That's the only time that the master is involved. Never before. Okay. When it comes to estates. And when I want to amend my will, very simple. I could amend my will myself by scratching out and adding in provisions, but I must make sure that it now complies with the requirements, the formality requirements for amendments, which is also contained in the Wills Act. You see, we always have rules for everything. Or I go back to my attorney and I say to my attorney, I want to amend the law that was drafted last year, can you do it? And the attorney said, of course. What do? They contact the will on the computer, they do the amendments, they print it out, and they give you a new will. Again, that will is an amended version, which you're going to keep in your possession, or you're going to leave with your attorney, and you're going to keep a copy. So you never have to worry about the master and involvement of the master until such time as somebody dies. Okay? Good. Yes.
Is it legal for a divorced woman to have investments in properties in more than one name?
Is it legal for a divorced woman
Okay, so
to have?
I have property which is in my married name, but I have investments which are in my maiden name.
Absolutely fine. As long as
They don't have to be changed.
No, we're not that pedantic. We'll be able to work out who the owner of the property is, because they will refer to your married name or your maiden name, and they'll be able to determine that it is you that they're talking about. Okay?
You can even have multiple married names.
Absolutely fine. So, like, if you're not in the bowling beautiful, you can have many names. Yes. When you go to the bank or the financial advisor, so you go to one of these First National Bank or whatever, what usually happens is the reason why they tell you you draft the will for free is so that they can be appointed an executor. So what's in it for them? They get 3.5% of the gross value of your estate, right? And 6% of any income received after death. So for them, depending on the value of the estate, the size of it, and remember, many small estates now makes a lot of money, they make quite a bit of money. So this is why people always assume that they can never change their will after that. Nonsense. If you draft your will today by Investec or by Sandbank, whatever else, you can decide tomorrow you want to go to a new attorney or a new financial advisor and draft a new will. The later will always supersede the earlier will. provided the earlier will is improperly revoked in your later will. Now the story. But okay, your later will always supersede the earlier will, and you can draft as many wills as you want. So this idea that somebody can tie you down, nonsense. But now if you went to the social bank and you said to them, I want you to draft my will for free, but I want to appoint my daughter's executor. But you say they're not going to do it for you. Why? Because there's no financial incentive for them to actually draft your will for free. Unless, of course, they really like you, like there's always a private client with lots of money invested, and they need to keep you happy and not do it for free of charge. Okay. But interestingly, and my colleague in the next 3 minutes, Mr. Nolte will tell you, services the university can offer you. If you need university money, and how they don't offer you.
Saying you're punting the university, I was wondering why you were punting CNA rather than Waltons. That's a serious question. You're punting trusts quite strongly, but you didn't mention anything about trust fees, which trustees who may not be beneficiaries of what you would be charged, and also taxation of trusts, because they're treated, as I understand them, as companies.
Yes. That's why I say to you, you must look at, when you go and start a financial advisor, then look at the pros and cons of everything. No matter who does work for you, you don't have to pay for it. If you appoint an executor, you must pay executors fees. You're going to pay master's fees. If you appoint a trustee, you're going to pay trustees fees. These things are regulated. Trusts are regulated by the Trust Property Control Act. So this idea that you're going to get a freebie does not exist. So you have to brace yourself with the idea that you will pay some fee. Okay. Of course, you can negotiate with people about the payment of fees. That's not a problem at all. But what we can't negotiate with is the fiscus, the receiver of revenue. So quite correct yourself. Trusts attract income tax. But remember, so that will be, if you create a testamented trust and you leave property to the trust, that's for the trust to pay, right? So it will attract income tax, it will attract capital gains tax, it will attract all of those things which natural people would. And people think this is very negative, but again, it depends on the circumstance in which you're in. One of the things you do not want to do is die, and there's R1 million which was going to a 7-year-old child. You do not want to do it. Why? Because if you left R1 million to a 7-year-old child, it gets put into the Guardian's Fund, which is regulated by the Master High Court. And it's regulated by statute, so you don't have to worry about the money going missing. But the problem with the Guardian's Fund is that it attracts very nominal interest. And it's got a very limited purpose for which it can be used. So if you want to create extended purposes like gap years and all sorts of other things for which money can be used for the maintenance of this minor child, the Guardian's Fund is not going to be able to do that. So that, in those circumstances, the Guardian's Fund is very useful. The same with children for disabilities. If you leave property to a disabled child, so let's say a mentally disabled child, impaired child, the property would pass to the hands of the person's curator. And that curator would then have to administer it. But you know what? It's better to do it by means of a trust. Because trustees can invest your money in blue chip shares, on this exchange, and that exchange, and this properties, and those properties. And the Trust Property Control Act is very good. What's also interesting about the trust is that you can vary the trust if there are changed circumstances, which you will not be able to do in the case of a bequest. Because once a bequest is given, and people can't change your intention, but trusts are something different. So you're quite good. You will attract all of those expenses, but sometimes, despite all of that, it's still in your interest to create a trust as opposed to just leaving an out-and-out bequest. Okay? Yes?
One small question, I don't know if it's in the wrong area. One owns different classes of assets, fixed properties, unit trusts, those kinds of things.
Yes.
How would you recommend one leaves those assets in a will? For example, if you leave a fixed asset, one clearly must have sufficient liquidity to pay for whatever transfers and all sorts of things from the died person to the new person. But if it's a unit trust, I presume those unit trusts in effect get sold and then has to be rebought by the new owner, and capital gains tax has to be paid. So one wouldn't then quote that this person gets a rand value, but the whole asset class, and it's subject to the liability of the capital gains tax in the process of transfer. How would one best do these things?